Sir, yesterday I was making a point that so far as the present bill is concerned, it tries to make the nomination a simpler procedure than what was obtaining under the old act. The only difference is this. As I said in the beginning, after the last general elections, it was found that in certain areas there were a number of applications which were rejected on the ground that the nominations that were filed were not found in order. Therefore, there was a feeling at one time that we might provide for some procedure by which that matter could be taken to some independent authority. That was the proposal made by the Select Committee, which was appointed in respect of the former bill, which was introduced in 1953 and ultimately withdrawn. However, when this matter was again considered by the Select Committee on the present bill, they thought that if at all the judicial authority was going to be interposed at this stage, then the object of having simultaneous elections was likely to be defeated. It might easily happen. Suppose the in respect of a certain matter of disqualification, the matter was allowed to be referred to some authority. It would naturally be subject to the proceedings that might be taken under the powers vested in the High Court under the Constitution or be subject to appeal to the Supreme Court. Therefore, the election program with respect to a general election would be set aside. Ultimately, it was thought that the best way to deal with the problem would be to try to obviate and eliminate as many chances of improper acceptance of applications as possible. Honorable members will find that the question of nomination for candidates is now made very simple and there is practically no chance of any nomination paper being rejected because it has been laid down in the act itself that the returning officer shall correct if there is a mistake with respect to the number or some such technical mistake. As I said yesterday, we have removed the restriction as to the number to which one voter may subscribe. But the only thing that is now required is that there should be somebody to propose the name of certain other persons. There was also a proposal by some honorable members of this House that we might do away with that proposal also. Then the next question is with respect to his disqualified on the ground that he was interested in government contracts or he was a convicted person and so many other things. In that connection, it was found that this was not a matter which could be summarily disposed of and ultimately it has to be left in spite of all that is said and done to the election objection which may take place. But I am sure that a man who wants to stand as a candidate to the Legislative Assembly, to a state or to the House of the People will naturally think twice before he applies. So that is the scheme so far as nominations are concerned under this Act. The next item refers to expenditure and honorable members are aware that after the general election, practically every party and every candidate complained that the form of return of election expenses was so complicated that it was difficult for them to comply with it. In the first place, there were some overlapping items or categories. Naturally, when a man stood for election, it was found very difficult for him to find out whether the expenditure was on account of the clerks, messengers, this thing or that thing. It was therefore found necessary that the complicated form of returns should not be there. What is now required is that the man should only keep an account of what he is spending and there should be some ceiling on the expenditure to be incurred because if there is no liability to keep an account, naturally the question of fixing a ceiling would be meaningless. It is from that point of view that some provision has been made in this bill to the effect that he should keep an account, and ultimately he should file a copy of the record. As the honorable members might be aware, in one of the cases, it was thought that there was no fixed date from which the candidate should keep an account, and one tribunal went to the length of saying that the man should keep an account from the time when he offered himself as a prospective candidate. Now, that difficulty has been obviated by saying that that account shall be kept only from the date on which the constituency is asked to return candidates till the date of their election. Then, sir, another important item was with respect to the program of election. One thing that I would like to point out is that formerly the program was rather considered to be too long, and now it has been cut down. Sir, this is a very simple measure. On 23rd March 1950, as the House is aware, there was a proclamation by the President, and accordingly, the President took over the administration of that state, and as the House is also aware, the legislature was dissolved. According to the Constitution, the power of legislation naturally vests in Parliament unless Parliament delegates that power to the President. Article 357 of the Constitution enables Parliament to confer the powers of legislation on the President, and therefore this bill has been brought forward for the purpose of giving to the President the power of making laws for that state. It has been found necessary that this power should be conferred on the President because there has been considerable congestion of work before both the Houses of Parliament, while so far as the work of legislation before the Kerala legislature was concerned, there was very heavy work there. In fact, as many as 23 bills were pending before the Kerala legislature when it was dissolved. I may point out to the House that there were as many as 16 official bills and 7 non-official bills. Out of these 16 official bills, in respect of 5, the Select Committee has submitted its report in the legislature. In respect of 9 bills, the matter was pending with the Select Committee, and the remaining 2 bills had been taken up for consideration, but before they became law, the legislature was dissolved. So far as the non-official bills were concerned, 3 bills were pending with the Select Committee and 4 bills had been introduced before the dissolution of the Kerala legislature. Out of these bills, there are certain which have to be immediately legislated because they are of considerable importance. We have received advice that so far as 2 bills are concerned, they are of a very urgent nature, and they are the Kerala Irrigation Bill and the Kerala State Aid to Industrial Amendment Bill. Both of these have to be attended to immediately. There are also 4 land reforms bills, and the Government of India will have to consider to what extent the provisions of these bills have to be taken up. Certain rights are to be conferred on certain classes of persons, and the sooner these questions are concerned, the better. As I already stated, there has been congestion or over-congestion of work before both the Houses of Parliament, and when this bill was drafted, 2 important considerations were taken into account. So far as the President made laws in the states were concerned, what the President had to do was to consult an advisory committee. So far as this committee was concerned, originally the idea was that the members ought to be 10 from the other house and 5 from this house, but it was found that honorable members from Kerala were much more than this number. It was also felt advisable that on this advisory committee there ought to be members from other parts of India, as well as those members who would take interest in matters relating to legislation in Kerala. Therefore, the government accepted an honorable member's view in other house, and the strength has been increased from 10 to 14 so far as the other house is concerned, and from 5 to 7 so far as this house is concerned. The total number of members from Kerala in both the houses is 12 plus 6. It is possible therefore to appoint some other members also, and this power has been given to the speaker in the other house and to the chairman in this house. Therefore, you will find that we shall have an advisory committee of 21 honorable members of both houses of parliament who will be ordinarily consulted excepted when the matter is of a very urgent nature, calling upon the President to make a law absolutely immediately. So, barring such instances, which may not be many ordinarily, you will find that the President will consult the advisory committee before he undertakes the work of making laws for the state. This is one safeguard according to which the wishes of the honorable members on this committee will be taken into account. Secondly, there is another safeguard that has been introduced. After the President has made the laws, copies of such enactments will have to be placed on the table of both the Houses of Parliament, and thereafter it would be open to the Parliament to consider them and suggest any amendments. If, for example, one house suggests certain amendment and then those amendments are accepted by the other house, then naturally it is incumbent on the President to issue another ordinance accepting the modification or the amendments suggested jointly by both houses of Parliament together. Thus, you will find that though the President is to be armed with legislative powers, these safeguards have been purposely introduced.